Hello, everyone. We are so excited to welcome you to the Law and Political Economy Group's conversation on practice and the Academy with Chair Lina Khan. Thank you so much to YLS Democrats, ACS, the Solomon Center, the Information Society Project, and the Oscar M. Rubhausen Fund for co-sponsoring this event. My name is Alora Landsberg. I'm a 2L at the law school, and it is an honor and an absolute privilege to be introducing Chair Khan and Professor Kapczynski today. Lina Khan is the commissioner of the Federal Trade Commission, where she champions policies that foster fair competition, protect consumers and workers, and ensure a level playing field in the marketplace. In less than 3 years in this role, she has implemented a groundbreaking proposal to ban non-compete agreements, rolled out new merger guidelines that work to ensure that the guidelines address the challenges of our modern economy, combated private equity roll-ups in the healthcare sector, and pursued a more aggressive stance against the mergers of large companies such as Kroger's and Albertsons. Prior to assuming her current role, she was an associate professor of law at Columbia Law School, counsel to the House Antitrust Subcommittee, legal advisor to then FTC Commissioner Rohit Chopra, and legal director of the Open Markets Institute. Before she became a leading figure in antitrust reform, however, she was a law student here in Yale Law School's class of 2017. While at YLS, she was one of the first students in law and political economy, and perhaps most famously, she wrote the note that jump-started the conversation on antitrust and anti-monopoly, Amazon's antitrust paradox. Chair Khan's achievements exemplify the enormous impact a person can have on the legal landscape. A quote from her that has stood with me is, "I'm certainly not somebody who thinks that success is marked by 100% court record. I think as public enforcers, we have a special obligation to be bringing the hard cases." This quote and Chair Khan's career serve as a testament to the degree of reform possible if we're willing to make the hard decisions, that even entrenched norms can be changed if we're willing to push back. She's an inspiration to me and to so many of us here at YLS, and we are thrilled to welcome her back on campus today. Speaking with her will be Professor Amy Kapczynski, the faculty director of the Global Health Justice Partnership and co-director and co-founder of the Law and Political Economy Project. Professor Kapczynski writes about LPE and the legal failures that contribute to inequality, scarcity, and a hollowed-out democracy, especially with respect to health justice and technology. Throughout her career, she has worked closely with social movements, aiming to help improve access to drugs in the US and abroad. This conversation will be live streamed via Zoom, and time is saved at the end for Q&A. And with that, I invite you all to join me in welcoming our esteemed speakers.
All right, wonderful to see such a crowd here and wonderful to have you back. We're going to structure this as a conversation and then save some time at the end for Q&A. So I wanted to start out with kind of a broad question. So you have come in as the new chair of the FTC at a time when there's a really, I think, a broad and fairly widely shared sense that there's too much concentrated power in the economy, and that that private power is negatively affecting workers, consumers, business itself. And a lot of things have shifted in, I think, how we have come to understand and the empirical evidence about markets in recent years, showing rising concentration, a strong degree of monopoly power, and bad effects that follow. For example, papers showing that consolidation in hospitals negatively affect wages of workers, or killer acquisitions in pharma, speak to areas that I work on, are negatively affecting innovation. And clearly, we have highly concentrated power in the tech industry with implications for the economy and obviously also for our politics and everyday life. So you were appointed not to sort of nip away at the edges of these problems, but really to make ambitious attempts to tackle them and make foundational kinds of reforms. And so I think the neo-Brandeisian movement with which you're associated, many people say, is kind of the dog that caught the car. So just to start out, how have you proceeded in this role to sort of set priorities and to think about generating a new approach? So I'd love to hear a few examples. So what you've taken on that you think is the most promising, either in reshaping sort of economic dynamics or political economic dynamics, or charting a new course for the agency.
Well, first of all, let me just say it's such an honor to be here. I actually took antitrust law in this very classroom. I see the portrait of Robert Bork is still up there. Also took IP law with Professor Kapczynski, and it's a particular honor to get to have this conversation with her since she was such a source of inspiration and admiration, and of course, such a key leader in the LPE movement. So there are a few ways that I think about priorities, one of which is, how are we determining the problems that we're focused on as an agency? And the other is, what are some of the key through lines that we're bringing to our approach across addressing all of those problems? So in terms of problems, one big focus is making sure we're addressing the biggest pain points that people face in their day-to-day lives. We're also thinking about particular business models, dominant intermediaries. We've seen a trend in recent decades of the proliferation of business models that centralize control and power while outsourcing risk and liability. We've also seen the expansion of dominant intermediaries that are playing an important role connecting producers and consumers, but we've seen that when they fail to be checked by competition or when they vertically integrate so that they're competing with the very entities they're intermediating, we can see problems. We can see exploitative practices, we can see conflicts of interest. And so be it, the FTC's lawsuit against Amazon, which we filed last fall, or the work that we're doing to scrutinize middlemen in the healthcare supply chain, both pharmacy benefit managers and group purchasing organizations, pretty opaque players that play a hugely influential role. Those are some of the kind of key issues we look at. We also think about, if we don't act, who else will? So, law violations that are also harming entrenched interests or well-resourced interests that might have the chance to bring their own lawsuits. We weight that sort of thing in our analysis too. A couple of just general approaches. One is making sure we're activating the entirety of the FTC's toolkit. So we enforce the FTC Act, we enforce the Clayton Act, we enforce the Sherman Act. There are provisions of the Clayton Act and the FTC Act in particular that have been somewhat dormant and somewhat neglected. And so we've been focusing on reactivating those to make sure we're doing our work with all of the tools that Congress gave us. We're also thinking about, how are we updating our skill sets and our tools? So we've been bringing on technologists to make sure that we have skill sets to understand how are some of these digital markets working. In our Bureau of Economics, we've been hiring labor economists, accountants, people who are bringing different skill sets and methodologies to bear to make sure that we're trying to mitigate blind spots.
Great. So as Laura mentioned in the intro, you wrote a wildly popular student note. I like to say to people, this was a much more widely read student note than I think 99% of the articles your professors will ever write. So in your writing, in that note and also other law review articles you wrote prior to this position, you set out a sort of both a critical and a programmatic analysis. And I know that the work you do now may be connected to this in some ways, but also may be quite removed from it. So I wanted to sort of say a little bit, many of you may be familiar with this work, but just sort of set out a couple of the sort of themes of it, and then ask you how that relates, how you see that work now and how it relates to what you're doing. So for those of you who don't know the work, it has a critical lens that argues that the deployment of, now I'm looking at Robert Bork, Chicago price theory, and both highly stylized descriptions of how markets actually work, and narrowing a set of concerns about what antitrust law should consider, for example, to consumer welfare or even more narrowly low prices alone, help to make, I think your point has been, help to make the enforcement of antitrust law really difficult and enable rising concentration and inequality. And then you and others have argued for a return to the statutory framework. What did Congress actually intend? And therefore to a more plural set of values, for example, incorporating concerns about the political power of firms or the situation of workers or small business, et cetera. So there's this kind of critical analysis, and then there's these constructive moves. So one is the idea that we need more structural rules and not squishy standards that make enforcement quite difficult. And the other is that we need more administrative tools such as rulemaking. So I'm curious how you think about that work now. Do these kinds of critiques and constructive moves really still inform the work that you do, or what might you sort of add or refine or change given what you see now in your position as the chair?
So I'll say a couple of things. I mean, you're absolutely, well, first of all, I should note that the posture of a academic or a law student writing an academic note is obviously very different from being a law enforcer. And so there are just certain freedoms and latitudes that you have as an academic that you just don't as an enforcer. So we're limited by the statutes that Congress actually wrote, the legal precedent on the books, things like our resource limitations. And so all of that really limits what you can do. That said, we have been focused on how do we make sure that we're activating our full set of tools. Congress gave us the ability to bring cases not just through case-by-case adjudication, but also through rulemaking. Both on the antitrust and consumer protection side, rulemaking as a tool had not been actively used in recent decades, and so that's something that we've been looking to revive. So we last January proposed a rule that would ban non-competes in the vast majority of employment contracts. We also have been doing a whole set of consumer protection rulemaking. That was partly done in response to an adverse decision that the FTC got before I arrived at the agency. This is the AMG decision in the Supreme Court, where the court said that the main statutory provision that the FTC had relied on to go to court and get monetary equitable relief, so redress, disgorgement, the court said, actually, this provision doesn't allow you to do that. So it was a really big step back for the agency in terms of the remedies that we've sought through some of our traditional statutory provisions. So that led us to then activate some of the other statutory provisions like rulemaking, where if you codify a practice as prohibited under rule, a rule violation can still trigger redress and civil penalties in ways that we think both helps make people whole when they've been harmed in the marketplace, but also hopefully can help with deterrence. On structural rules, I mean, I'll just say, a core through line across our work is making sure we are both looking at the text of the statute, but also looking at the legal precedent actually on the books. So there's a whole set of case law. Some of it's quite old, from the 50s and 60s and the 70s. That's still good case law. It's never actually formally been repudiated either by that circuit or by the Supreme Court, but there's been a tendency to ignore it or pretend it doesn't exist or pretend that it's been overridden. And, as a law enforcer, I don't think we can just pick and choose, which words we read in our statute, which words we decide to ignore, which precedents we pretend are not really there. And so we've been just undertaking this work in a way that tries to be really faithful to the law. The merger guidelines that we issued and finalized in December really reflect that as an approach. And so for the first time ever, the guidelines actually include citations to the law, which initially was somewhat controversial, but then I think that in part reflected that, antitrust law had become somewhat unmoored from the regular moves that you see in all sorts of other areas of lawyering. It really ended up being governed much more by certain types of econometric models that I think made us, in some instances, diverge from what the law actually said. So in the guidelines, we also note that the structural presumption is alive and well. Since issuing those guidelines, we've started to bring cases that also reflect that approach. Obviously, how the courts are going to fully engage with the guidelines is an open question, but some of the early results have been quite positive.
Great. I wanted to just follow up with a question about the non-compete rule. So that's an area where, there are quite clear potential consequences for workers. And that's one feature, I think, of the new Brandeisian approach, is to sort of emphasize the interest in the experience of workers. And so I know people might not be familiar with both the general issue, like what's a non-compete, and what you've done. And I thought that might be an interesting way to kind of describe a little bit more about how some of these also other issues that we're, I think, seen of as more peripheral to anti-competition law or consumer protection law kind of have fit in the way you thought about it.
Yeah, so a big goal for us has been making sure we're enforcing the law in a way that protects everybody. That includes consumers, but it also includes workers. It also includes small businesses. This is not something that's exotic to antitrust. It, in fact, was a core part of how lawmakers were thinking about who the antitrust laws would protect. And, precedent throughout the last century has also vindicated the idea that antitrust law protects workers, protects honest businesses, protects entrepreneurs, in addition to consumers. The area of non-competes is interesting. There was, there are some states like California that have long held that non-competes are not enforceable. And a non-compete clause is basically a contractual provision that prohibits an employee from working for a competitor to their current employer for a certain number of years, usually, within some particular geography. And so it basically constrains the post-employment options for employees. These non-competes started off in the boardroom, mostly applying to the C-suite, but over the last few decades, they've really proliferated across sectors, across income levels. So you have, fast food workers, janitors, journalists, engineers, doctors. I mean, really people across the board that are now governed by non-competes. Over the last couple of decades, additional states have started to introduce laws that limit the reach of non-competes. And that has allowed researchers to do is to isolate with more precision what are the empirical effects of non-competes, comparing states where you're able to have non-competes, enforce them, with states where you aren't. And that research has really surfaced a couple of things. One is that non-competes harm workers. They suppress worker wages, we estimate, by up to $300 billion a year. And that affects not just the workers that are directly covered by a non-compete, but also workers that aren't. Because if the workers who are covered by a non-compete are not able to exit their current employment as readily, that limits job opportunities for the workforce as a whole, right? There's less fluidity, there's less churn in the across the entire labor market. And so we estimate that this rule could, significantly return higher wages to workers. There are also impacts on the product market side. So we've also seen that non-competes, perhaps unsurprisingly, given they're literally called non-competes, hurt competition, right? And so oftentimes the entities that are best positioned to enter the market or serve as a competitor to existing incumbents find that their ability to scale or grow is limited because the relevant talent pool is locked up by non-competes. So the FTC would actually hear from businesses, some of who'd been able to, secure capital, build a factory to try to disrupt an existing market that was dominated by a monopoly or an oligopoly, but they found that they quickly, hit a limit as to how much they could grow because of non-competes. So there are impacts on the labor market that are negative. There are impacts on the product market that are negative. And so this was a rule that we introduced last January. We got over 22,000 comments, the vast majority of which were significantly in support of these non-competes or support of a proposal banning non-competes. A lot of the comments were actually from healthcare workers, including doctors, nurses, physicians' assistants, talking about how non-competes had really restricted their ability to, to go work for competitors, but also things like during the pandemic where healthcare workers, wanted to be mobile so they could go help out in areas where COVID was flaring up. They found that they actually weren't able to do that because of these non-competes. We actually saw in some instances that healthcare workers were not able to provide care as readily during the pandemic, even though they wanted to because of these. So really a range of effects on wages, on product market competition, and also just the availability of service.
And you're known really for your work on competition and antitrust, but of course the agency also has a consumer protection mission. And, so there's been a bunch of actions in that space. I'm thinking of work on so-called junk fees. Also, I think my personal favorite, the one about that, I don't know what you call it, the technical term, but not getting trapped by when you sign up for the app and then like, how do you unsign up? How do you stop your subscription? Click to cancel. Great. I knew there was a term. So I wondered if you want to talk a little bit about how you think about the consumer protection work you've done, maybe some examples there, and like also how that fits with the mandate around competition and the broader mandate of the agency.
So the agency enforces the prohibition in the FTC Act against unfair or deceptive acts or practices. So we prohibit deception as well as unfair acts. And over time, kind of the agency has ebbed and flowed in terms of where it's focused in terms of those provisions. Starting in the 80s, there was a really a thinning out of the consumer protection paradigm, where there was a view that the real goal of consumer protection enforcement is to make sure that people aren't tricked in the marketplace. And so it assumed a set of rational actors in the marketplace who, if they just had the right set of information, would be, protected and able to really fend for themselves. And that information would also then promote kind of efficient functioning of markets. And so it was a really, I would say, narrow conception of what consumer protection is about. I think we've seen in a whole set of ways how just focusing on companies not tricking people is not enough oftentimes. And so we've been focused on activating the unfairness component of our authority in addition to deception. Unfairness is there's a statutory standard fleshed out in the law where it talks about, there has to be a substantial injury that was not reasonably avoidable by consumers and that is not offset by benefits to consumers or competition. So there's kind of a three-pronged test. One thing that we've been thinking about is what counts as an injury. And so it's long been recognized that monetary harm counts as injury, but we've been thinking about things like harms to privacy. And so if you're being surveilled or if your very sensitive data is being collected or sold without your permission, that can also cause harm that we believe we should be able to vindicate under our unfairness authority. We've also more generally been looking to shift the burden. So in our privacy work, for example, we've brought a set of cases where we've said that there is a presumption against companies being able to sell your sensitive data, like your geolocation data, your health data, your browsing data. It's not enough just to bury some disclosure in the terms of service, which can always be updated or changed on a whim. You really have to get people's affirmative permission to engage in those sorts of practices. So I would say kind of, expanding how we think about what counts as injury, and then also where we can shifting the burden so we don't have this vision of our work where it's, about just only informing consumers or ensuring that they're well equipped, because we've seen that, especially in markets where consumers don't face a lot of choice, it's not enough just to make sure they're informed. They really are entitled to more robust forms of protection.
Great. And now I want to go on to some of the sort of critics. You've attracted a lot of attention given what you're doing at the agency, and criticisms that come, I'm just going to sort of say from the right and the left, although those are complicated criteria in this context maybe. But so maybe just to pick up on the non-compete and the click to cancel points. I mean, I think there it's a traditional way, those of you who've been educated in the 1L curriculum may well be sort of versed in the sort of law and econ-y way of talking about how we should think about those things, like, well, you signed the contract. And so, this is about enabling choice, as you said, consumers, you clicked that app, so you've signed that. And so what we ought to do is enable choice in this context. Maybe if some consumers don't pay attention, a few will, and that will drive the market in new ways. And this is going to be the best way to organize a sort of free marketplace. And so obviously the things that you're describing are sort of pushing against that traditional way of thinking about, both in the consumer protection and the competition context, sort of thinking about what choice means or what freedom means. But sort of, I think the conservative critics that you might hear in the media, I think broadly make claims that sort of this way of proceeding of sort of is to move away from sort of tractable, analytically, empirically good price theory kinds of things, and displacing that with something sort of more either politicized or more discretionary or even paternalistic. So I wondered how you answer that challenge. Sort of, are you in practice, sort of, what does it mean to move away from the sort of mainstream assumptions of the way consumer welfare standards or these other sort of choice ideas worked? And also, what's the alternative, or how do you think about what the alternative is?
So a key focus of ours has been really to focus on empirical reality. I think one pathology that we've seen sometimes is a over-reliance on models or theories that just stop being attached to what's really happening in the marketplace. And so be it through our research, be it through the types of, economists or other skill sets that we're bringing on board, we're really focused on making sure that our diagnosis of what's happening is right. One way we're also doing that is by opening our doors. And so we regularly strive to hear from just regular people. We do that by having comment dockets that are inviting people's views on, are there particular coercive contractual terms that you're encountering in the marketplace? We do regular commission meetings where anybody can sign up and come talk to the commissioners to share, what are problems that they're seeing in their day-to-day lives that should be on our radar. And so through a set of tools, we're really trying to understand, the markets and the economy as it is, rather than through the prism of certain theories or models that I think we've seen sometimes can lead us astray if they're not constantly updated to what's really happening. I think we've also seen that the predictability or determinacy of some of these models has sometimes been overstated. And so one example is, in antitrust, there's become a lot of reliance on certain types of econometric tools, some of which can sometimes be quite useful. But we've seen in practice is that courts and in particular judges have actually grown quite frustrated with it. And so, and I should just note, as an agency, when you're bringing an antitrust case, when you're going and hiring an economic expert, these experts are expensive. I mean, a ballooning part of the FTC's outlays has actually been these experts. And, in the years before I arrived, the FTC's Inspector General actually identified ballooning expert costs as like a source of risk for the agency. So here we are, spending millions of dollars on these economic experts to, put together this very sophisticated analysis to help us win in court. And when we go to court, the judges hear from our expert, they hear from the defendant's expert, and in a whole bunch of instances, the judge has basically said, your experts kind of cancel each other out because I don't, the truth is, really understand what's going on. And so I'm going to rely on, which witnesses sounded more credible. Right. And so just from seeing how this has played out, I think we have reason to doubt that in some instances, the type of analysis we're doing is actually aiding the courts in coming to their right conclusion. And so I think that just should prompt us to revisit how useful is this analysis? How can we make it more useful? Does it make sense for us to be spending millions of dollars of taxpayer money on this type of analysis if it's not actually helping the ultimate inquiry? In some ways, the agency's hands are tied, right? Because if defendants are doing this, then we can feel like, well, we also need to do it to be able to go toe-to-toe with them. But that's just one area where I worry that there's a mismatch between the kind of analysis we go through the motions of doing and the ability of judges to fully take that in and have that be part of that analysis. I think that's also why relying more on things like structural presumptions can be quite useful. And one critique of structural presumptions is that they can be quite arbitrary in terms of where you're drawing the line. But I think just there are all sorts of aspects of the law that are just making arbitrary determinations, right? And the task of the agencies and the courts is just to figure out how to be applying that in particular contexts.
I'm thinking of an event I was at not long ago when a panel with an economist who had served on the European Competition Commission and who came out, had gone in, I think, thinking we need perfect economic analysis and came out saying, actually, you can't do it inside of an agency that way. And so very much, I think, in line with what you're describing. But yeah, do you want to say anything more about either the use of sort of these open hearings and sort of different kinds of experience or structural rules that you think might be able to sort of overcome some of these issues with the way expertise is and isn't kind of mobilized in helpful ways?
Yeah, I mean, I should say, first of all, economics is not a monolith. There are different disciplines and subfields within it. And so one thing we've just been looking to do is just make sure we're broadening our toolkit, right? Economists can play an enormously valuable role in antitrust. We are lucky to have, over 100 PhD economists that provide essential work at the agency in terms of helping us do both our antitrust and our consumer protection work. But we're just mindful that, every method and tool has its blind spots. And so the more that we can be diversifying some of the methods and tools that we're bringing on board, be it within economics or be it things like bringing on technologists, that can help us make sure that we're fully understanding what's happening in the market and what the effects of that are. You had asked about.
Oh, I was actually thinking also about the ordinary, like
the
bringing
ordinary,
ordinary people into hearings.
Yeah, I mean, I think, we're trying to broaden how we think about expertise, right? I mean, the people who are living the reality of their markets and the day-to-day life are experts on how these markets work. And so making sure that we're hearing directly from them is incredibly important, both as we pinpoint problems that we think are important for us to devote resources to take on, but also to make sure we understand the kind of mechanics and nuts and bolts of how things really work. Be it, understanding what are the contractual terms that as independent pharmacy is having to deal with, imposed by the PBM, or understanding, why is it that the kind of assumption of perfect bargaining power between these two parties is not really what's playing out. And so that type of on the ground understanding of what's really happening is really important. I probably have a bias towards it because I got my start in this field as a business reporter and journalist, where I would just talk to a lot of people to understand how are things working, antitrust experts, but also the people in these markets, be it, farmers or retailers or whoever it is. And so I personally place a lot of primacy on that and think our agency as a whole can benefit from it in terms of broadening the expertise, but also making sure that we're staying democratically accountable, right? And showing what it means for an agency to really be representing the public and serving the public.
Great. So to come back to sort of some of the critiques, I would say one way to think about some left-wing critiques would be that competition is sometimes problematic for workers and businesses, and that you can't really sort of democratize the economy through competition and consumer protection rules. That instead you need some kind of bolder action, maybe public options or public utility models, things like that. So I'm sort of curious how you would react to that.
So look, I completely agree that competition is just one tool in the toolbox, and there are other paradigms, be it the public utility, be it, public options, be it enabling kind of cooperation and coordination, that all have their place. As an agency, we're kind of limited in terms of, having the antitrust laws and the consumer protection laws to enforce. So those are just the prisms that we look at problems through. But I think, it's well known that at various points over the last couple of decades, antitrust agencies actually aimed their fire at workers that were looking to coordinate and collectively organize. And so, there was an effort in Seattle to be allowing independent contractors to be collectively organizing. And, the Chamber of Commerce viewed that as unlawful forms of collusion or coordination, and the agencies ended up backing that view. And so I think from our perspective, one thing we can bring is understanding kind of being humble about our domain, and not viewing kind of competition as having primacy in all and every area where Congress may have made other determinations about. There's an explicit carve out in the Clayton Act to allow for worker organizing that's interpreted as covering employees. And so there's currently a gap in terms of not necessarily recognizing that independent contractors should also be enjoying those rights, but just as a matter of, prudential, strategic, where you're placing priorities and where you're not, you can take those types of enforcement decisions.
Great. So I wanted to now sort of dig into some of the challenges of implementing a new agenda like this, and ask you about a couple of sort of concrete things, and sort of name them and say, is this a major concern? And if so, how do you think you should navigate them at the agency? So one is resources. So there's a sort of famous story, Luke Heron tells it in a new piece about unfair competition law, where there's a sort of big backlash against the agency in the 70s and 80s, where its authority and resources were really cut, from which my understanding is it's never really recovered. Now, every head of an agency, I think, will say that they need more resources. But I wondered, how much of an issue is resources? How much can be done by, you suggested switching to more structural rules to maybe make it less dependent on mobilizing of expensive experts and so forth. So yeah, say a little bit about the challenge of resources at the agency.
Yeah, look, it's a major challenge, and the size of our economy has grown, at least threefold since the 1970s. And so the idea that we've been, frozen in place effectively since then is a major challenge. On the antitrust side in particular, I mean, these cases take a lot of people to put together and to be able to actually be up in court. They're very resource intensive. And so, it doesn't take a lot of cases, either investigations or live litigations, to really start maxing out on what your capacity is. On the merger side, where we're in reactive mode in terms of what comes in the door and where we face pretty strict timelines and deadlines, vast majority of which are outside of our control, the resource limitations end up being a major strain. And so, around 2021, there was a merger boom where filings were just off the charts, and it ended up creating enormous strain for our staff, but also we knew that we were not catching everything. And even when we did spot something, we oftentimes didn't have the people to devote to it. So it ends up being a major problem. We've been lucky over the last couple of years that Congress gave us a bit of a budgetary increase. And so we have been able to do more hiring. But I would say we're still pretty far from where we need to be able to start addressing the scope and magnitude of the problems we see.
Okay, now I want to ask you about the courts. So you mentioned a recent setback in the courts before you had arrived, but there's also major Supreme Court cases this term challenging Chevron and the very idea of deference to agency rulemaking, and major decisions potentially undermining the system of adjudication through administrative law judges. And of course, we have the major question doctrine. So major questions, whatever the Supreme Court thinks, seems to me is a major question. That doctrine, which has really sort of been constructed over the last couple of years, seems to me also potentially significant for every agency. So how specifically do you think about these issues as they affect the FTC?
They're very much something we're tracking very closely. In particular, the issue around our administrative adjudication has already had a real impact. So one of the cases that was pending when I arrived at the agency was the Axon case, which teed up the question of if there is a defendant in our administrative adjudication that wants to launch a constitutional challenge to the agency, can they do that at any time during the proceeding, or do they have to wait until they're in a court of appeals appealing a commission decision? And so that's somewhere where we got a decision, a 9-0 decision saying, well, actually, if it's a constitutional claim, parties can go and seek simultaneous review. They don't have to wait until the very end, which can end up being quite disruptive in terms of the ability of parties to basically freeze your administrative adjudication. We've also seen ongoing challenges relating to, the removability of commissioners, challenges relating to the combination of powers that Congress has given our agency in terms of, semi-adjudicative, semi-legislative, some would call them quasi-legislative, and prosecutorial authority. So, some of these legal challenges are squarely directed at the FTC. Some of them are directed at other agencies like the SEC or the CPSC. And so, our team follows all of those developments very closely. We actually had a very good outcome in the Fifth Circuit a few months ago in our Lumina Grail case, where the parties had also raised a whole set of constitutional challenges. And they got to pick which venue they were in. They went to the Fifth Circuit, presumably assuming that was a more favorable circuit for them. The Fifth Circuit opinion ended up basically swatting away a lot of those constitutional arguments, all of them, in fact. So that was a really positive development for us, but we know that this is a live issue. We follow it very closely, very much thinking about our rulemaking through the prism of the major questions doctrine. We'll wait to see what the court does in the Loper decision and where Chevron deference ends up landing. And so it's very much top of mind for our general counsel and her whole team as we think about how do we move forward with this work in a way that best positions it to survive in this judicial environment.
And I think then maybe the last question about challenges is about the broader political economy. So one of the things that we who talk and think about law and political economy emphasize is that economic power can translate into political power. And so on the one hand, you presumably have a fair amount of opposition from companies that don't like this new set of rules. So maybe you want to talk a little bit about how that manifests, or you see that opposition in your current work or the influence that it has. And then on the flip side, does the FTC have a role to play in sort of helping organize countervailing power in the economy emerge? And sort of how do you think about that, whether that might be consumers or other kinds of business interests or workers?
So on the latter question, I mean, we're somewhat limited in how explicitly or expressly we can be enabling that. I mean, for workers, for example, it's really NLRB that's best positioned to be making sure that workers are able to exercise their rights to organize. I think this is more where some of our prosecutorial discretion comes in, and make sure, we're not wielding the antitrust laws in a way that's, targeting workers that are looking to organize. I think also the type of forums that we do to make sure that we're hearing from people, hopefully can also create a way for people to be recognizing that they're not isolated in how they're facing these problems. One striking thing, given the purview of the markets we look at, is you really see analogies across markets in terms of the business practices that are occurring. And so, a farmer realizing that they actually have something in common with a gig worker because they're both being subjected to, coercive contractual terms by the middleman that they're subjected to, whose power they're subjected to. I imagine those types of commonalities being surfaced can also probably help contribute to that. And your first question
was about corporate power.
Corporate power. Yeah, look, I mean, it's a reality. The monopolies can have a lot of economic power, but also political power that can play out in a variety of ways, including, their engagement with Congress. I do think one really interesting aspect of this work is the fact that there is some bipartisan concern and anxiety about the role of monopolies and the outsized economic power that they have. And so that continues to be, a through line where we see a lot of concern on both sides of the aisle about, PBMs, for example. And so that's exciting to see as well.
Okay, so last two questions. So how do you think the experience you've had will either shape the scholarship that you may do after this job, or in generally, what should academics be doing differently given what you see from where you sit now?
Yeah, I mean, it's probably too premature to weigh in on, what things will look like on the other side. I do think as a general matter, in antitrust, there's been, in antitrust scholarship, there's been a lot of focus on substantive doctrine and doctrinal analysis, which is incredibly important. But I do think that the institutional aspect of antitrust sometimes gets short shrift. There are scholars like Bill Kovacic, like Daniel Crane, that have written about kind of the institutional dimensions of antitrust. But now being in an antitrust institution, I think that type of analysis can be quite useful.
Okay, I'm going to ask one more question and then we're going to go to the audience. And my last question. So I know that there are about 1 million students who think, how can I become Lina Khan? What can you tell them about how to become Lina Khan, what you did that helped you get here, and also whether you think you'd do anything differently, knowing what you know now?
So, I mean, to state the obvious, I think there's a lot of serendipity and luck involved in people's trajectories. I should also note that, there can be setbacks along the way. What ended up becoming YLJ note got rejected at least once, but I think twice by the journal. I also, after law school was set to clerk, and my judge ended up passing away a couple of months before I started. So things don't always take a linear path. I think one, disposition that I have that has served me well is just curiosity, like just really curiosity about how things work, including in markets. And so I think, especially when you're thinking about, areas of economic power, having a ground level understanding of how things really work out in the real world can be extraordinarily useful. I also, when I came to law school, I knew that I was interested in corporate power generally, interested in antitrust, but decided to structure my course load in a way that exposed me to the different parts of the law that were most directly shaping and structuring corporate power. So that included antitrust, but it included IP, included trade law, which ended up being one of the more fascinating just parts of the law and the kind of quiet ways that it ends up shaping corporate power. First Amendment law, given that companies had been wielding First Amendment challenges to major regulations. And so that type of kind of broader purview and looking at a particular problem or issue from different vantage points, I found very helpful. I also did a clinic here, the Mortgage Foreclosure Litigation Clinic, which was also just really great experience and exposure to, more real lawyering, and also just like directly interfacing with the people that had been, harmed by wrongful foreclosure.
Okay, so now your turn. So what are your questions? All right, we'll start in the front here. Oh, maybe just say your name.
Like many people here, I'm a great fan. Right after the Great Depression, there was like a large outcry against chain storage, not because of price concerns, because of localism concerns. And as your efforts show, antitrust law can work in the public interest. So I'm curious if you think this public interest includes maintaining economic and thus political power within local communities specifically.
So yeah, I think that set of cases is really interesting. And the Patman Act was also passed around there, which was also concerned about the ways that, dominant retailers had the ability to be squeezing independent stores. So, these are ultimately legislative decisions and policy decisions for Congress to be making, but I certainly think that a through line across a lot of these anti-monopoly laws has been a concern, not just for the ways that monopoly affect price, but also how they affect, civic society and the, way that the power and control and coercion can really undermine people's experience of citizenship. So I think, through the legislative history and some of the cases, we've seen that that's been an important through line.
Yeah, in the back.
I'm wondering about sort of side, but like accreditation with goods, so things like organic or energy stuff, things that are as well as those conducted by nonprofits like Whole Grain Council or leads or for buildings, and whether it's a different approach to regulating those practices.
So the FTC, primarily approaches this through the prism of deception. So if there are representations being made that are actually not entirely accurate or are ultimately misrepresenting or misleading people, that falls in our purview. We're less involved in kind of, explicitly directly overseeing, especially for some of the private entities. We do more explicitly oversee dry cleaning labels, so the labels on people's clothes. We also have something called the Green Guides that offer guidance on, if you're marketing your products as sustainable, how to make sure that you're not being misleading and what are kind of minimum standards that need to be met to make certain types of representation. So it's really more about, for the most part, enforcing kind of the law against deception and misrepresentation rather than substantively engaging with what's being represented and trying to push that in a certain direction. Great.
Thank you so much for being here, Chair Khan. My name is Gustavo. I'm thrilled that you're here speaking with us. So a former staffer of yours commented the other day that a key disappointment was visiting here in the progressive movement for economy was the pushback to the expiration of the child tax credit, the pandemic era child tax credit. I know this is a little bit outside of your purview, but speaking to the realm of like a fair economy, I'm curious if you could comment from your experience before you were the FTC chair about this sort of problem where perhaps there's too many progressive resources in policy-wonk organizations and not enough progressive resources towards creating more durable mobilization structures that can create policy feedback and create a political movement when things like CTC expires, as your former staffer was commenting on more of. So here's if you could just sort of remark on that.
Yeah, no, it's a really interesting question and kind of one more generally that I think the advocacy community faces and that, funders think about as they're figuring out where to be dedicating resources. I mean, really the kind of model here for me is Adi Barkan, who, was just a real trailblazer in terms of making sure that arcane issues relating to the Fed became more popularly understood and legible, right? Because the Fed in many ways is, the archetype of an area of policy making that's really removed from people's day-to-day lives, but has huge, impact on the economy and on how easy it is for people to be getting jobs. And so, that type of work that's really helping mobilize people around what can seem really arcane and technocratic areas of the law, I see as playing an important part. One aspect of our going out and doing more of these field hearings and really opening our doors to hearing from the public is that I think people start to connect the dots more between, why they can't find infant formula on their shelves and policy decisions that are being made, right? And so the more that there is that feedback loop between the problems that people see in their day-to-day lives and their ability to realize that these problems are not inevitable, right? There isn't just some like technological determinism that's getting us here, but these outcomes are actually can be the result of concrete policy choices or legal choices that are or are not being made. I think that feedback loop can be incredibly important, and also from a perspective of institutional durability, ensure that whoever comes after us in these roles is also going to continue to be held accountable, right? If more and more people recognize that, that arcane decision that FTC is making could end up having sweeping implications for what my groceries cost or how what my employment options look like. I think those types of feedback loops are incredibly important. Yeah.
I'm actually a student over at the School of Management. Thank you for coming. It's very inspiring to see a fellow American high school student.
Oh, nice.
For me, it's just going to be going into competition policy work, actually in a few months full time. What advice would you have about how to work well and communicate effectively with lawyers and legal professionals?
Yeah, it's a really interesting issue. And especially as we start to do things like, bring in more technologists in our agency, just seeing on the ground some of, the pain points just from an institutional perspective about how you get people that speak different professional languages to be able to work seamlessly together is really interesting. And I mean, I'm sure there are others that are better positioned to weigh in on that, but I think, thinking about what are the comparative advantages you're bringing in terms of, I imagine you have particular understanding of how to be thinking about things like deal rationale or business strategy, which, when we're thinking about merger analysis, because the type of legal analysis that we're doing can sometimes be, very, very focused on micro questions. Some of the macro can be skipped over. And so I imagine that will be one area where, coming from more of a management perspective will be really useful. Yeah.
Here's how your agency is considering consumer protection versus especially in certain areas where they kind of blend together. And I'm thinking of the agency's litigation against Amazon, which for the consumer protection one, like click to cancel, and then the competition litigation with regards to buy boxes and stuff, which those seem to be very similar concepts, but they're being brought like competition versus consumer protection.
Yeah, it's an interesting question. And, embedded in the agency's DNA is actually a much more integrated approach to competition and consumer protection. So when the FTC was created, we only had unfair methods of competition authority. And the way we ended up actually going after deception and fraud was by saying that fraud was an unfair method of competition because it injured honest businesses. So it was an interesting way to kind of be using competition authority to go after what ultimately later became kind of consumer protection problems. And throughout the century, you know, if you look at FTC complaints, they oftentimes were pleading both unfair methods of competition and unfair and deceptive acts or practices. One goal of mine has been to make our agency, you know, look at these problems in a more integrated way. We have a Bureau of Competition, a Bureau of Consumer Protection, and, you know, sometimes they can be quite siloed. And so making sure that we have practices in place so that, you know, if the same company is in fact being investigated on both sides of the house, you know, how can we make sure we're doing that investigation in a more integrated way? When we make these types of decisions about, you know, are you doing one case or are you doing two cases? There are a whole set of considerations that factor into that, including timing, including, you know, a particular case can max out in terms of the number of issues it's addressing, in terms of, you know, even things like, okay, if we're going to have page limits in our briefing, is it really tenable to have, you know, what effectively are two separate cases, or is that going to start compromising our ability to really brief the case? As well as things like, you know, what are the remedial options that we'll be able to get in one case versus the other? And are we going to have more state partners and state AGs on one? So there are a whole set of considerations that play into that, but we have been really focused on how do we make sure the two parts of our agency are talking to each other and working together. And, you know, it's already having payoffs internally, even at the level of like, you know, two teams investigating the same company. They both asked for certain, or one team asked for certain documents. They didn't get them, but those documents ended up showing in the other team's investigation. And so then, you know, the other investigation was helped. So really nitty gritty ways, but also conceptually, we're really encouraging teams to be thinking about both sides of the house.
I'm going to ask one follow-up question on that. I'm just curious I don't think consumer protection is taught very much, and antitrust is taught a lot. And if you think is that broadly right? And does that need to change, right? Or would it be better to teach like a course on the FTC and about the integration of those? I know you're not sitting here as a law teacher, but no, you've thought a lot about these questions, and I know you guys are thinking about these questions. Like, how should we think about teaching this material?
Yeah, it's true. I mean, at least in my experience, you know, consumer protection was not offered as a standalone
Still not, I
class,
think. Yep.
which is pretty striking, both because it's, you know, a big part of federal law enforcement, but most states have what are known as mini FTC acts that are also enforcing unfair, deceptive acts or practices. So it is a pretty important part of you know, how we're doing our work. And so it definitely seems like a gap.
Yeah.
Second on that. So it's the kind of intersection between different branches. So you've mentioned trying to leverage tools that exist. I wonder though, if a member of Congress came to you and said, "Hey, I'd love to help you," if there were one or two wish list powers that Congress could grant you, what do you mean?
So I would say fixing the kind of remedial problems that we face in terms of, especially on the antitrust side, the only thing we can really get is an injunction. So we're not able to get money back for people who've lost money to monopolistic practices. We're not able to get disgorgement. We're not able to get civil penalties. And so just from a redress perspective, that can be quite limiting. So that would be one thing. I guess, you know, more generally, there are, and one thing I've asked our teams to do is, as we're doing our investigations, and as we're bringing our cases, to actually be keeping a list of where are the areas where we see those gaps, to make sure that we can, you know, send a letter to Congress at the end of my tenure being like, we tried to use the tools you gave us in the most faithful way here where we think there are gaps, because I do think that feedback loop is really important between the different branches. So yeah, I think remedial authorities is top of mind. I think to the extent that Congress thinks, you know, providing more structural rules in antitrust is the right way to go from an administrative perspective, administrability perspective, I think that could be quite useful.
Great. Yeah.
My question really has to do with the president's current industrial use. What do you see the FTC doing with its current investment in the industries of the future investments? Yes.
So I see these intersecting in a couple of ways. Obviously, different policy goals, but I do think they intersect. So one example is, the government's been giving out a lot of money to try to encourage U.S. production, U.S. manufacturing, money to encourage green transition. Anytime that the government is giving out money to the market, there ends up being opportunities to structure that in a way that's promoting monopoly or in a way that's structuring competition. And so keeping those competition considerations in mind. And so even things like, with electric vehicles, making sure that you're promoting interoperability with those vehicles. You're not basically just allowing, a repair monopoly to emerge. I actually visited a independent repair shop a couple of weeks ago, an auto dealer, who was sharing that as cars are becoming more digitized, right, computer on wheels, these repair restrictions that manufacturers can implement have huge ramifications. I mean, he basically said if nothing changes in the market, if manufacturers are not required to basically allow independent repair, my shop's going to be out of business in 5 years. So huge ramifications in terms of competition. The other area where we've seen a lot of money being given out is in agriculture. So the USDA and other parts of the government have been giving out money to small and medium-sized farming operations to try to encourage, more competition there. But if, you can imagine a world in which an existing incumbent tries to buy out one of those small and medium operations. And so if you don't have vigorous antitrust that's policing those types of mergers, you could end up seeing, huge pot of money goes to setting up these small enterprises. Those small enterprises end up being bought up by one of the existing monopolies. And so just in terms of policy goals, you've seen that pretty undermined. So I do think that there's a role here. This administration and this White House has really focused on a more whole of government approach to competition policy. And so in summer of 2021, the president signed an executive order that was basically charging agencies, including the FTC and DOJ, but across the board, to be thinking about how is their work structuring competition and how can we be all rowing in the same direction. Yeah.
Thanks so much, Chair Khan. My question relates to kind of like your vision about like empowering the entrepreneurs and how, from a broader LPE perspective, sort of stronger antitrust enforcement could potentially work in sync with like a deregulatory agenda in certain ways. I think, for example, like within like the healthcare industry, there's a lot of like consolidation of like care delivery, and part of that is like banning physicians from like owning their own hospitals. So how you could see potentially the two.
So the role of kind of relationship between antitrust and regulation.
Yes, and like people talk about like supply side progressivism and how like deregulatory push could, for example, achieve like broader competition.
Yeah, it's definitely true that sometimes antitrust and regulation get kind of pitted against one another. I mean, I'll just say on your initial framing of the question, antitrust laws, if they're enforced properly, are designed to create open, fair, and competitive markets in a way that I think would entirely empower entrepreneurs, right? I mean, if you have a good idea and you're able to bring that idea to market, you want to be able to have the chance to succeed, right? Rather than getting crushed by one of the existing monopolists that feels threatened by you. And so I see from that perspective, the interests of antitrust and entrepreneurs pretty aligned. More generally, I do think we've seen instances in which antitrust and regulation can either be at cross purposes or can actually be mutually reinforcing. And so it's very context dependent. I think sometimes we see the worst of both worlds, where you've seen, a deregulation as well as a neglect of antitrust. One of the architects of the airline deregulation, Alfred Kahn, was interviewed in the late 90s after a lot of airline consolidation had happened, and we were already seeing some of the shortcomings of that. And he was asked, 20-something years on, how successful do you think airline deregulation has been? And he noted that, a key premise of his assumption had a key premise of his when designing this policy would be that you would have robust, vigorous antitrust. And that, deregulation combined with a decline in antitrust had actually created the worst of both worlds, where you had a few dominant carriers that weren't seriously checked by competition in that way. And so I think, anticipating some of these issues on the front end when either creating regulation or deregulating can be really critical.
In corporate power in agriculture and monopoly power in agriculture. And I sort of see the issue as, or I guess antitrust issues generally, as sort of the government being the only entity that is sort of powerful enough to go toe to toe with like major corporations at markets. But as also we noted in this talk, there are limits to what the government can do, or there are resource constraints, etc. And so I am curious to hear what you've seen as sort of effective, I guess, non-governmental strategies to break up corporate power, maybe specifically in agriculture, or like, I guess, what can be done to again sort of like these alternate channels figure out.
Yeah, it's an interesting question, and I certainly don't assume to have all the answers. Antitrust laws also have private rights of action, and so we have seen instances where private litigation has been successful, though antitrust litigation in particular is very expensive, and so it can be quite difficult for private parties to be bringing those cases. I think historically we've seen that technological inflection points or inflection points in the market can be important moments for disruption and for new players to be coming in. So from a technological standpoint, it was the advent of the middleware and the browsers that ended up threatening Microsoft's monopoly in the operating system. The DOJ case against Microsoft ended up ensuring that this next generation of players were able to emerge and thrive, and we were all able to enjoy, at least for a period of time, some competition there. I don't know what the analogous inflection point could be in agriculture, but that's, in some areas historically how, forces outside of the government or kind of interventions outside of government action have injected competition. Yeah.
My name is Laura. Thank you so much for your talk. I was really struck by how you told the people who have been harmed with such care. You talked about finding methods of redress that very fundamental. More about that and maybe illustrate what are the forms of redress that help people pull out the experience really being taken advantage of by corporate actors, and maybe what enables people to enter into contracts from a position of power and affords them something a little bit closer to what I think is the convenient fiction of rationality, autonomy, and choice that you kind of alluded to earlier. But yes, I guess sort of two separate questions. How do I read that something about order and power?
On redress, sometimes our mechanisms are quite crude, right? So the most crude is just money. Have you, been defrauded out of money, or have you ended up overpaying, and how can we get you that back? One innovation that we've been introducing is money for time wasted. And so recognizing that the time that people are spending, as a result of illegal behavior is also something that they should be compensated for. We've also been thinking about, for instances where companies are unlawfully obtaining data, they actually need to be deleting that data and also deleting any models or algorithms that were created through that unlawfully acquired data. And so, those are just some of the mechanisms of redress that we think about. But I think you're right that at a more kind of experiential level, those types of harms can be difficult to fully compensate for. And the second part of your question, remind me?
I guess how do you ensure people when they're entering in the contract?
Oh, right. Yeah, I think a couple of things. One is for certain types of, predation or abuse, I think you really just need bans, right? You're not gonna, in the way that, we have like food safety regulation that just creates certain floors across the board to ensure a base level of safety. I think oftentimes you need that type of backdrop regulatory structure to make sure that there are basic provisions in place and you're not just leaving people to fend for themselves in the marketplace, whatever they can pay for and whatever, they can bargain for. I think beyond that, really understanding the underlying conditions for when people do or don't have a choice can be quite important. And so one dimension of that is competition, how many options are there in the market? How easy is it practically to be switching between different providers? And so a more reality-based understanding of how real choice is or is not in the market, I think is key.
Great. I know we've got a number more questions and apparently some also on Zoom. I think we only unfortunately are going to have time for one more question though, given the need to stop at 1:30. So I'm just going to over here.
I'm a PhD prepared nurse, so I'm a health services researcher, and my interest is looking at hospital mergers and how they impact the nursing workforce and patient outcomes. So my question is, as a non-traditional player from a different discipline, how can we come together and kind of bringing all those different perspectives together instead of maybe traditionally just thinking about law or policy or economics kind of work.
Yeah, I mean, at a very basic level, when we see hospital mergers, we want to make sure that we're hearing from all the people that it could affect. And so that very much includes healthcare workers. One of the cases that we voted on a couple of years ago, we were in a split commission, so we weren't able to actually include this, but a colleague and I would have voted to actually include a count that would have said the merger was bad, not just for patients, but also for nurses, because we had heard from nurses about concerns in the recent lawsuit the commission filed against the Kroger-Albertsons merger. We also note that the merger would harm unionized workers. So building the muscle to be analyzing how mergers affect not just consumers, but also workers is a big area of focus. And so continuing to kind of engage directly with and hear directly from healthcare workers is a big part of that. Our policy levers are somewhat limited in terms of the overall healthcare space, but always, eager to be engaging and hearing about ideas for how the FTC can be better acting in the space.
All right. So thank you so much for taking this time with us, and thank all of you for your wonderful questions. So please join me in thanking the chair.